Welcome to the Legal Hour podcast presented by Bailey Galyen. I'm Michael Galyen, and today we're joined again by Kern Lewis. Kern's been on the podcast a few times before, but I'll give a brief introduction that Kern is the Director of Catastrophic Injury at Bailey Galyen, which essentially means he handles very serious cases involving very serious injuries. He is board certified in civil trial law and commercial law by the Texas Board of Legal Specialization. Plenty of years of super lawyer, national trial lawyer, top 100 for many years, rated by the National Trial Lawyers as a top 25 brain injury lawyer, also a member of the American Board of Trial Advocates, or ABOTA, for those who know about ABOTA. And Kern went to ACU, or Abilene Christian University, for undergrad, and Texas Tech for law school. And so the first question I have is, what made you want to stay out in West Texas?
Oh, you mean to go to Tech for law school?
Right. I mean, going from Abilene to Lubbock, for the listeners who don't know, I spent some time in Lubbock because that's where I went for undergrad. And, driving through Abilene on the way to Lubbock, there's not, between Abilene and Lubbock, there's not a whole lot out there.
Yeah, and so an honest answer to this question, I will lose all credibility I have with people. Actually, when I finished at Abilene Christian in beautiful Abilene, Texas, I had a full scholarship to Pepperdine Law School, which is in Malibu, California.
Right.
And I was within just a few weeks of moving to California to start law school there when I decided to go to beautiful Lubbock, Texas, instead of Malibu, to go to Texas Tech. The reason was a professor at ACU had set up a lunch for me to have with Jack Pope, who was the Chief Justice of the Texas Supreme Court at the time.
Right.
And when I had a lunch with him, and he was asking, well, what do you want to actually do? Do you want to be a lawyer and try cases, or do you want to be like a professor and teach? And I was like, no, I would think I would want to actually try cases. And he said, I think you should go to Texas Tech. I think it's the best law school in the state of Texas, and they're putting out the best trial lawyers. So I changed my mind at the very last minute and went to Lubbock instead of Malibu.
Well, all the decisions we make along the way bring us to where we are today.
You never know.
And you make an interesting point about Jack Pope, right? He was I was reading the longest serving Chief Justice of the Texas Supreme Court, I believe. And it's interesting for a school like Abilene Christian, that's smaller university, especially in Texas, they have a lot of, say, for lack of a better word, high profile lawyers that went there. I mean, you have several federal judges in Texas. You have a current Supreme Court justice on the Texas Supreme Court. What do they have in the water there in Abilene that's creating all these great lawyers, yourself included?
Well, I think, number one, the school's motto is to educate students for service throughout the world. So there's a real service mentality. And being a judge, I think fits that. Also, one of the benefits of a smaller school like that is you get to know your professors and you get to know administrators. It was not uncommon at all for me to have dinner with professors and go to their houses and get to know them and their family and maintain relationships with them long after I left the school. And when I decided to go to law school, I originally started, I was a chemistry major in college. And there was a subject called organic chemistry,
right,
which changed my mind and made me decide to go to law school. But when I did decide to go to law school, I had a number of professors who actively reached out and did things to help me. They would say, I know the dean at Pepperdine, or I know the dean at Texas Tech. Let me call them and set up an interview with you. So they really helped. And at the time I was there, for a small school, they had the highest acceptance rate in the nation for students graduating being accepted into either law school or medical school.
Wow.
So almost everyone I knew, well, I can't think of any, everyone I knew that wanted to go to law school got accepted and went on.
So the jury's out on whether it's something in the water or maybe.
Exactly.
Yeah. Well, I'm sure I missed a whole bunch of accolades when I went through that list. And I know it's sometimes sitting where you're sitting when somebody's going over the accolades and everything like that. You kind of sit and blush or cringe or whatever the reaction is. But I think it tells a story about the experience you have, not only trying cases, helping clients throughout your years of practice. And so we appreciate you taking the time to come on the podcast because obviously you do have a lot of cases and clients to take care of. And so one of the things that I wanted to ask you about, and you touched on this a little bit in your meeting you said you'd had with a former Texas Supreme Court justice. What made you think, even at that time, that trial work is what you wanted to do?
So when I actually started at law school, I wasn't sure that I wanted to do any kind of trial work. I actually had it in my mind that maybe I'd like to be an entrepreneur and just have the degree so that I was familiar with business, because my undergraduate degree was in finance, and just be a business type lawyer. And at Tech, they're very proud of their trial advocacy programs, which consists of two different things. One's called mock trial, where you go through a pretend trial where you call witnesses, you argue to the jury, the whole thing. And they have a competition in the school among all the first years, have to be on a mock trial team and compete against each other. And then the schools, all the law schools nationally, have competition teams where they have a team, it's like their football team, that they send to compete against other schools. And the American Bar Association puts on this big competition. And that's kind of a big deal in law schools about who wins the mock trial competition and how they're ranked nationally.
Sure.
And my first year, when I did the first year mock trial program that everyone has to do, I did pretty well in it. We didn't win the whole thing, but we did pretty well. But I decided I really like this. And the professor who was the coach of the competition mock trial teams to compete against other schools asked me to try out, and I tried out and I made it as a second year. I was on the competition team both my second year and third year of law school. And so I got to go around the country competing against other law schools in these competitions, and I loved it. Then the other type of trial advocacy program is called moot court.
Right.
And that is a pretend or simulated appellate argument. So you don't have a jury, you don't have witnesses, but you're merely arguing the record as if you were arguing to the Supreme Court. It's a panel of judges, and they ask you legal questions, and you have to argue and use logic to persuade them to your side of the case. And so I was also on the school's competition moot court team.
Were you really?
Yeah, so I did both, and we got to travel around and do those things. And that's when I knew I was going to be some kind of litigator.
Sure. Well, and that, it's interesting. I feel like a lot of law schools today, and I don't want to speak too broadly, but at least in my experience, are creating this next generation of lawyers, or have been for some time, to write memos or, which are creating big law first years, essentially. Let's write a memo on some legal issue and you're not actually doing any of the legal work. Or the other side of things is they're trying to create law clerks. And so they're really focused on appellate drafting and briefing, pretty complex legal issues. And you get out of law school and you want to practice trial work or anything like that. And well, how do I draft a lawsuit? How do I discovery? What's discovery? Do you feel as though that's maybe an issue that a lot of law schools are kind of veering away from litigation practice, going more toward the big law first years and clerks and things like that?
Well, I haven't been in the law schools recently to really know what they're teaching, but my impression is that the practice of law has changed in that it is so much harder now for young lawyers, especially, to get to trial, to get any kind of trial experience. Because lawsuits have become so much more expensive, the law firms are billing hours and they're, staffing the cases with so many lawyers that they almost all end up settling. So not as many cases actually go to trial.
Right.
The ones that do go to trial, it seems like, are the small car wrecks, the fender benders, or they're the very, very large, horrible accident cases where there's so much money involved that people are more willing to take the risk and say, we got to try this. Settling, it'll cost too much money. Maybe we have a chance to win.
Sure.
So I think the young lawyers just don't get to go to trial like we used to. I've been doing this, it'll be 40 years in November. So when I started 40 years ago, and it was not a matter of fact, when I got sworn in, so you get out of law school, you take the bar exam, you wait for your results, and you're working at a law firm while you're waiting to find out if you passed the bar, and then you're officially licensed. And you get the results, so you start working there, let's say in August, but it's November before you get the results.
Right.
I was at a firm where we tried so many cases that I got my bar results, told I had passed, and then you have to have a judge swear you in. I actually had a judge swear me in the morning I started a trial. Judge, before we start, you need to swear me in. Yeah. And I know the lawyer on the other side was licking his chops,
sure.
Just going, oh, this is going to be great. So
that's not really how it happens today.
No,
right?
No. You go to the big law firms, there are people who've probably worked there 5 or 6 years and never had a trial.
I mean, in some cases, never even taken a deposition.
Yeah. I know you look at people's biography and they'll say representative cases, and when you see what they're bragging about on their experiences, summary judgment. They're not mentioning trials, they're mentioning summary judgment. So it's just harder to get that kind of experience nowadays.
Sure. And I mean, I've run into the same thing being a more recent law school graduate than yourself, but it is difficult. And the problem is there are so many areas of law when you're doing, trial practice, whether it be first chairing a deposition or voir dire or any of the different metrics of trying a case, that you can watch as many as you like, but until you're the one standing up in front of the jury, all focus of the courtroom is on you, or let's say first time as a deposition, you're first chair, and you need to make sure you check all the boxes with a specific witness, that you won't know how you're going to react and how you're going to perform until you're in that position, right?
Mm-hmm. For sure.
Speaking of, you have tried a lot of cases, taken a lot of depositions, done all the things, and I'd like to ask a few questions about certain experiences, because when I was preparing for this podcast with you, I was thinking of some personal experiences of mine in my limited time of practice, and thought, I bet Kern has much better stories than me. And so one of the ones that I was going to ask is, because I had something happen recently with me in a funny scenario that I can go over, but when you're doing a voir dire, and for those who don't know, voir dire is just the jury selection. Before a trial even starts, the attorney for the plaintiff, attorney for defendant, they get up and ask the panel of potential jury members questions before a jury is picked, and there's some other stuff that goes into it, but that's generally what's going on. Have you ever had a voir dire where you just had a panel member really stick out to you, or just said something so outrageous that you stopped her, the judge had to interject, or just something that stands out when you think about that?
I smiled because the first thing that popped in my mind was the most embarrassing experience.
Yeah.
In picking a panel. So you've got like 60 people out there sitting in the pews of the courtroom, and you're asking questions about, do you know anybody? Have you ever had an experience like this? And one of the questions was, that the other lawyer asked was, is there anyone on the panel who knows either of the lawyers?
Right.
And this hand on the very back row goes up, this small hand, and it was a girl that I had been on a blind date with just a couple of months earlier. And she, of course, said, well, I know Mr. Lewis. And he said, oh, how do you know him? And she said,
No.
well, I went out with him once, and the place just erupted in laughter. And so he was like, oh, well, was that a positive experience or a negative? And people were just dying laughing, and I'm sure I was 3 shades of red. So that's an interesting one on the panel. I can remember one where I had a number of lawsuits that I tried with a couple other lawyers, because these would be big cases that involved a lot of money and a lot of witnesses. So we would try cases together and we would divide things up. You're going to do this. And I remember my partner trying a case, and at the time, he had grown his hair a little longer because he was doing it for a friend's wife who had cancer, and he was doing this thing called locks of love, where you grow your hair and then let it get cut. But anyway, so his hair was a little longer, touching his shoulders, and there was a guy on the panel who was a colonel in the Air Force or something, and he let him know real quick, is there anything that anybody's got a problem with about lawyers? And this colonel just ripped him about your hair. Is, I can't believe you would come to a courtroom so unprofessional and all this kind of stuff, and just really chewed him out about his hair. And he, just said, well, would it make a difference to you if you knew that I was doing this for a program called Locks of Love? We're growing hair for children with cancer who need wigs. Oh man, and the rest of the panel was just like, yeah, looking back to that colonel. So that's one that comes to mind.
Yeah, no, and those are good. The reason I brought it up, if you'll humor me for a minute, is I had a voir dire in San Antonio in Bexar County a few years back, and one of the general questions that are often asked during voir dire is, before you know any of the facts about this case, just looking at the parties involved and their attorneys, is anybody starting out behind, whether because you don't like defendants or you don't like plaintiffs or you think one side is. And a gentleman in the front row raised his hand, and I was like, yes, sir. He was like number 3. So obviously at that point, he hadn't said anything that was going to get him really struck. And he goes, oh, is that the plaintiff? And points at my client, who's a man. And I said, yes, sir. And points at the defendant. And that's the defendant, who's a younger female. I said, yes, sir. And he goes, well, men are just better drivers than women. And so before, I even know what happens, I would just assume that your client was in the right. And the judge was a female judge, and I was sitting there just, thank you, sir, for your answer. And we get time to go to the judge to do strikes. And this is the opportunity where the judge asks the parties, hey, did anybody on the panel say anything that would make it to where they probably shouldn't serve on this jury, whether they're biased against one side or they were in some experience that was too similar to the case and they couldn't be fair, or whatever it may be. And the other side says, well, what about juror number 3? And the judge looks at me and says, any objection to striking juror number 3 for cause? And I was like, Judge, no. I was like, there's no, yeah. And I thought that was hilarious because although he would have been a good juror for me, I was not going to lose credibility with the judge that early and before we even started the trial. So anyway, one of the other things that I was thinking about, because trial practice these days, like you'd mentioned, can be, say, very detailed. There's a lot of attorneys staffed on them. A lot of discovery is done. A lot of depositions are taken. And oftentimes, even pre-trial can oftentimes take days, whereas, in smaller cases or maybe in the past, you do pre-trial the morning of, doing motions in limine and other things that are kind of giving the judge giving you a bit of parameters on what's going on in the case. But have you ever had an experience where a ruling just before the trial began or something from pre-trial that happened that had you have to think on your feet or totally try the case in a different way or something along those lines?
I'm sure I've had where a judge will rule at the very last minute that a certain witness is not going to testify.
Right.
And you have to learn to just tuck and roll, and just flow with it and say, okay, fine. I can think of situations where you say, well, judge, if that's what you're going to do, that's effectively a death penalty sanction, meaning the case cannot be won or lost, and therefore we would ask you to grant a continuance so that we have time to address that. And most judges, if they know it's going to result in what's called a death penalty sanction, the appellate courts have said you shouldn't do that.
Right.
So, but I can think of situations where someone wasn't going to get to testify, and you just have to adapt and say, okay, well, we'll get this in through somebody else, or we'll just,
Right, or a witness not showing up. And luckily, sometimes you do have the deposition transcripts and try and get it in that way, but
yeah.
You really got to think on your feet.
Yeah, you do. You have to be flexible. That's one of the things that over 40 years of doing this, I have become less tied to notes or outlines of the questions I'm going to ask a witness, because I have found I had to do that when I first started.
Right.
Because, you have to learn the process. But I have found when I have a list of questions, I tend to go from one question to the next rather than listening to what the witness says. Mm-hmm. And if you just really listen to what they're saying, they will sometimes use a word or a tone or something that'll lead to 5 other really good questions if you're paying attention and don't miss it. But if I'm just reading a script, I'll miss it. So I've found that being conversational is one of the most effective ways to question a witness.
Yeah, that's a good point. And I felt when I first started, like you'd said, I was like, well, I don't want to miss these certain elements I need to get from this witness, but I'm sure the amount of good follow-up questions I missed out on by not actually listening to their answer is just...
I will have a list of, I need to prove these 3 things, like A, B, C, D, or these 5 elements, but the individual questions I won't write out.
Yeah, that makes sense. Okay, so have you ever, off the top of your mind, can you think of a situation during either voir dire, opening, closing, where you've got to use a real fun demonstrative or used an analogy that really stands out to you that you think made a difference with the jury, or even that you just had fun with it?
Okay, so on the analogy side, I really like analogies of using a story. It's almost like, if I can go back to my ACU background, Jesus taught in parables.
Yeah.
The best way to get someone's attention is to tell a story. And so an analogy is just a story that illustrates the same principle or the same situation. And I was trying a case in federal court in Dallas, and it was against the city of Dallas. And it was for a homeless man who had been arrested, put in the jail, and he had pneumonia when he got arrested, and they put him in the jail, and so he was very sick, and they just threw him in this big tank of people, with a whole bunch of other people, and he was very sick, and even the other inmates were going, this guy's really sick, y'all need to get him a doctor and stuff. And they gave him such poor medical treatment, he died in the jail. And at that time, the conditions in the Dallas jail were pretty known to be pretty terrible. And there were federal lawsuits against them for constitutional violations. So anyway, we were representing the family of this homeless man, his father and mother and sister. And the defense was that, look, he's a homeless guy. They didn't see him that often. Really, how possibly upset could they be that he died? So really, there's not much value here. And they were really downplaying to the point I thought of being insulting to the family about the value of this person's life. And there's a reason he's homeless. You know, he had some mental problems. He had some mental problems usually lead to self-medication and drug problems. And so these things had been going on, but the parents still loved him. And the parents were always hoping that he would come home, that he would come back and live with them, and that they let him take care of him and that kind of thing. And I remember on the jury, there was a woman who was a minister at a Baptist church in Dallas. And she was a very educated woman, a very classy woman. And you could just the whole way she carried herself, you could just tell she was smart and classy and very calm and well-spoken, and she was going to be respected by everybody on that jury. And I just knew she's going to be the foreman of that jury. Just everything about her says she's going to be the foreman. And she was the minister at a church in a very underprivileged section of Dallas. So I know that she had empathy for people with a lot of problems. Anyway, so
Sure.
I wanted my closing argument to be focused to her, that if I could persuade her, she would bring everybody else along with them. So my closing argument, and this was something I had not planned a long time in advance, but it just kind of hit me that morning as I looked at her and prepared. I got up and said, I want to tell you all a story. And I started telling this story about a long, long time ago. You know, there was a man who had a son who came to him and said, I don't want to live at home anymore. Give me my inheritance. I want to go do my own thing. And this is a biblical story called The Prodigal Son. And the son goes off and he lives in the far country and he ends up blowing all his money and feeding the pigs, and he's destitute and he's homeless. And the moral of the story, though, was that the father is waiting for this kid to come home. And the father sees the kid coming home and runs to meet him. And so I use the analogy that, well, even though this kid was doing, you know, bad things and a lifestyle that we wouldn't approve of, and he was homeless and he was destitute and he was sick, his father was always waiting for him to come home. And so the idea that the parents, just like the prodigal son's parents, were waiting for him. And as I was telling that story and it became obvious, I was using the biblical parable, that lady, she was nodding her head. She knew exactly where we were going. And the jury was out less than 30 minutes.
Wow.
And usually when they're out that quick, that's not good for the plaintiff.
Yeah,
because
right.
There's a number of questions they have to answer. And if they can get it done in 30 minutes, they probably just answered the first one no, and you've lost. They came back in 30 minutes and gave us almost $1 million.
Wow.
Which was really high for the situation we were in.
Sure.
So,
yeah, and yeah, I think it's a good point that if there's a way to simplify an issue, whether it be through a parable or an analogy, because you want to get the jury to, feel for your client in a way that they understand. You know, it's tough to say that they can understand what they're going through because they can't. But if you can compare it to something that they may feel closer to, then they'll likely feel closer to your client. And I think that's a great way to try and do that. But how about, and the reason I thought of adding demonstrative to the question is because anybody who's gone into your office will see that you still have some fun demonstratives that you've used. And I remember in a case that you tried maybe 2 years back or so when there was a specific judge that was giving you trouble for one of your demonstratives. So I know demonstratives are a big thing for you. What are some fun demonstratives that you like to bring up when people ask you?
I had a medical malpractice case involving a man who was shot while driving his car. A bullet came through the window and hit him in the head. It came from the back and hit him in the back of the head. He was able to drive himself to the hospital, go in the emergency room, and they told him They looked at his head and said, "Man, you're really lucky. It just grazed you. We're just going to give you a tetanus shot and send him home." And they sent him home, and he passed out and woke up several days later. And a friend took him to a different hospital, and they went in and said, "Well, you've got a bullet in your head and in your brain. It's lodged in the skull, but it's protruding into the brain." And, they had to do emergency brain surgery and all that. So I had the CT scan, which is like a film, an x-ray, where you could see, it's like picture the circle, the top of his head, and you could see the bullet sticking in the corner of the skull, half in, half out. Mm-hmm. And that's what I originally was going to use at trial, the scan showing the bullet, and that they missed it. And if they had just taken an x-ray at the first hospital, they would have seen it, and that was malpractice. But at the last minute, I sent that scan off to a company that does 3D printing and had them print a 3-dimensional skull from that scan. So it was exactly like the scan with the bullet sticking out. And I was able to pass that skull around to the jury where they hold the skull and they can see the bullet sticking out and say, if the doctor had just felt, you could feel the bullet sticking out. If he had really just done a good examination and felt, he would have seen it. And so that's probably one of the most impactful ones I can think of.
Sure. You get a lot, any objections from defense counsel on the demonstrative?
No, I mean, it's the 3D scan. It's the scan. All I had to do is have a doctor say, yeah, that's...
Yeah, fair enough. I mean, I could just foresee if, from the defense counsel's perspective, they're just like, any way I can keep that out.
Yeah.
But what are they going to do, right?
It's one of those things where sometimes for the defense counsel, the more they object, the better. Because that's like waving a flag of, we don't want you to look at this, we don't want you to see it, especially if you've already shown it to the doctor and asked them about it and authenticated it. They ought to just, no objection would be the smart thing to do.
Right, and then to the extent that they can try to address it later, they address it later.
Right.
They'll have the opportunity during their case to try and found evidence to the contrary. But that brings me to an interesting point that I think, do you feel as though that there are a lot of attorneys, and it could be on the defense or the plaintiff side, but that will oftentimes shoot themselves in the foot by objecting so often to certain things that they don't like, or it even may be a scenario where they're just trying to break up the flow for the other attorney, and ultimately the jury's just turning on them because, you know, they start to get upset with this guy is just taking everybody's time here, objecting to everything.
Exactly. A good example of that. And when I am in trial, I object very little. If I'm not confident it's going to get sustained, just don't object. Shut up, be quiet, act like it doesn't bother you. And a perfect example of that is if you've seen the movie A Few Good Men with Jack Nicholson, Tom Cruise, my favorite movie, by the way. There's a point where there's an expert witness on the stand, and Demi Moore's character stands up and objects. And then it's overruled, and she sits down. And then he says another opinion. She stands up and objects and says, "I strenuously object." And the other two lawyers, Tom Cruise and Michael Pollock, are going, "Oh, I strenuously object. Is that how it's done? You strenuously object." It just draws more attention to it.
Right. No, that's a very good point. One of the other questions I had for you is that people often like to say that cases are settled on the courthouse steps, or that, you know, well, if we can only get them to the courthouse steps or into the courtroom, they'll settle once they realize, you know, we're really serious about trying it. You know, setting aside the fact that at that point you've already done all the prep, so we might as well try the thing. But do you have any fun examples or interesting examples of cases literally being settled at the last second?
I've had them settle on the steps. I've had them settle after you pick the jury, when they get a good look at who's going to be hearing, or how the people responded to the voir dire questions, and they see who's going to be on the jury, and they go, "We don't like this jury."
Yeah.
You know, I had one case where their best offer to me had been $5,000. They were going to, kill us. They were going to win $5,000. This is a nuisance suit. And at the end of jury selection, they offered me $1 million.
Wow.
And we turned it down and tried the case and got $5 million on the verdict. So I've seen that happen. One of the most interesting ones was I was trying a case in Oklahoma. And so a little setup to the funny story is sometimes during trial, especially after you've done this a number of years and you're more comfortable with it, we would come up with little games to play during trial. And my partner and I, we would come up with a game where we would give each other a word that you had to use. Well, sometime during the day, either talking to the judge or the jury or a witness, you have to use a word. And you get a check mark, if you use the word. And so we were talking in the lobby, sitting outside the courtroom among ourselves, hey, what's my word for the day? What's your word? What's, word? And a lawyer from the other side was sitting out there and heard us doing this. And it was the young lawyer on their team. They had an older lawyer trying the case, but a young lawyer on the team heard us talking about what's my word. And the word they had given me was bullwinkle. I had to use the word bullwinkle at some point during the trial. And this kid was just in shock that we were so cavalier, I guess, about, trying the case and that we were playing this game. And so we went in and I'm questioning this lady and I managed to use the word bullwinkle. She was talking about that her nephew had been in the house watching TV, and I said, oh, was he watching Bullwinkle cartoons? and when I did it, that young lawyer on the other side went, he made a noise. So later, we've finished the case, we've finished the trial, we've done closing argument, and the jury is out deliberating. And the other side, they're going hours, and this is on a Friday, and the jury has told the judge they think they can finish, they want to stay and finish that night, even though they're staying late. So it's like 10:30, 11 o'clock at night, and We're still sitting down in the courtroom. And this is in Lawton, Oklahoma. And so we start talking settlement between the two of us, because the fact that the jury's going this long, there's always ways to interpret it. They went long enough, maybe they're past the first question, which is the liability question. Maybe they're on damages, or maybe they're arguing about this. So both sides get very nervous. What could this mean that they're taking so long? So we start talking settlement. We come up with a deal. Okay, we've settled the case. We have to go back in and you have to announce it to the court and have the court reporter take it down that you've settled the case. And the jury's still out,
right,
talking while we're doing this. So we're dictating it on the record that we've settled this case for, it's a decent sized sum of money. It was $500,000.
Yeah.
We dictate on the record that, yes, we've agreed to settle this case for $500,000. The judge goes, okay, I'll approve the settlement, blah, 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 blah. And right at that moment, the buzzer rings that the jury has got their verdict.
Oh.
And the judge says, I don't want to tell them you've settled. I want to hear their verdict.
Yeah.
They've worked this hard and this long. Let's let them come in and announce their verdict. And they came in and announced that they had found 0 damages. And we had just settled for $500,000, 5 minutes earlier.
Oh, man.
So that was pretty crazy.
Yeah, that's a pretty tight one. Well, like I said, I know you're busy, so I think we're going to call it there for today. But I really do appreciate you taking the time, telling these stories, and I'm sure we could go a few more hours, and you would still have more, but we'll have to save those for next time. Well, that was another episode of the Legal Hour presented by Bailey Galyen Attorneys. We'll see you in the next episode, and we are off the record.